What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about some court cases that have been settled in the favor of plaintiffs when debt collectors were sending letters to people they were trying to collect money from. And we're talking about third party debt collectors because they're under the Fair Debt Collection Practices Act and they have to communicate to people who they're trying to collect the debt from under that law. And uh, you'll see that a lot of them have actually violated the FDCPA, Fair Debt Collection Practices Act, by the way that they communicated with their envelopes. But because the knowledge, the understanding of the law, people mostly thought that the communication was within the actual letter, that it was only the letter or a call. They never figured that the first part of a letter communication is the envelope that the letter came in. And there's numerous cases that specifically went into the way that debt collectors were sending letters. And I'm going to have some examples posted here on things that you need to watch out for. So, bottom line, a lot of times people just want to know, they're like, Steve, what is the bottom line when it comes to what they can and can't put on an envelope? I can tell you the bottom line on an envelope to it from a debt collector is that they cannot make it look like it's a debt collection on the outside envelope. It has to really be bare. It has to be bare. It can have their name in the corner. It can have a metered stamp because a lot of companies they don't like going to the post office. They'll use the meter stamp, but they cannot get that processed by a third party company. So a debt collector can't send a file over to a mailing service company and have them print out the letters and have them stuff the envelopes and have them mail them out. They're not allowed to do that. A lot of them do it all the time because you don't want to sit there putting together envelopes and stuff. But this is the rule, and the rule is because they don't want people's privacy to be violated. They don't want people. If the Fair Debt Collection Practices Act state that you have a right to privacy and that it's between you and them, and number one, when they're sending that first letter, it could be something that is totally not true. So if they're going to expose your information, say something about a debt that you potentially owe or something that is wrong, and then they're sending that to a third party company to mail it out, and or they're violating all types of laws by the wording that they put on the envelope, that's a problem. And that's a major violation. And you can have your debt cleared away simply, regardless if you owe the debt or not, you can have it simply cleared away or have this whole problem go away based off of the violation that a debt collection company makes with the envelope. So I'm going to give you some court cases, and the statute or in the Fair Debt Collection Practices Act, it's 1692 F8, paragraph 8, and it's about placing their name on the envelope, placing your information on the envelope. So there's a Casey versus uh, it says the name of the company is Judgment Enforcement Law Firm PLLC. Another one was Rittner versus Collection Accounts Terminal. This is probably a one from a company with this Collection Accounts Terminal. And then Simmons versus Med I Claims. And there was Guashman versus American Collection. Some of these companies aren't even around anymore. Johnson versus NBC Collection. So uh, let's just look at the top reasons why this these lawsuits were brought. So on one of them, it says that they believe that the collection agency violated Section 1692 F8 because the purpose, it says that it apparently prevented embarrassment resulting from conspicuous name on the envelope, indicating that the contents pertain to debt collection. So, like I said earlier, they cannot, like, this envelope has to be plain. And this is also why a lot of these companies started changing their name to Portfolio Recovery or Jefferson Capital or Midland Credit Management. Like, they started changing their name. They used to have a name like ABC Collection Bureau or Johnson Collection Agency. They used to have all of these types of names. And then you started seeing that these lawsuits were coming out because people started understanding and they were like, hey, you can't put that on there when you're a third party debt collector. And so they started making those changes and they were like, hey, we got to change these names because we're actually in violation. And when people start to understand that we're in violation just by simply putting our name on the envelope, that we're in trouble. Now, some of the other things that you got to watch out for is they can't put stuff on there like final notice. They can't, like, your original creditor can do that. Your original creditor is not under the Fair Debt Collection Practices Act. But if your original creditor uses a debt collector, the debt collector cannot utilize that information on an envelope. So that is the thing that you got to watch out for. And I think that one of the reasons why a lot of debt collection companies got away with it is because when people receive the information, they're more focused on the debt. They're not focused on any violations. And I mean, and 9 times out of 10, the debt did belong to the individual. So it's you know it's right. The focus is rightly on thinking about the amount on the debt. But what I've always said is that once you establish if the debt was sold or if it's from the original creditor, and there's no violations, uh, you do have potential means to not have to pay that debt. And the way that I see it, and I'm a businessman that also has people who have not paid their debt to my various companies, and this is just part of it. You don't want people not paying a debt, but this is just part of the system that we live in, and that if a person buys a debt and they cannot prove every aspect about that debt that the individual has to pay, that individual is not going to probably have to pay that debt. And I don't think that there's uh, really anything wrong about it, because if the debt is proven, then there's going to have to be some type of negotiation process to get that debt paid. So let's skim through real quick some more of the things. So on the envelope, if it's from a debt collector, the debt collection company, a debt collector who has purchased a debt or a debt collector who is collecting for an original creditor, they cannot make the envelope look like there's something like you owe this debt. They're not allowed to do that. If it's from the original creditor, yes, the original creditor can do that. So on this one here against American Collections, which I'm pretty sure they've changed their stuff around. So it says here, uh, envelope with a half thick blue bar across the front with the words priority letter in white did not violate the code, which it wouldn't violate the code because this could just be a letter that is, you know, priority, the way that it's sent. Even though the thing though is that that letter was not sent by priority mail, but the court said that itself did not violate because of the wordings. Uh, and then it says here, because the subsection only prohibits marking on the outside of the envelope that are unfair or unconceivable, such as markings that would signal that it is a debt collection letter intend to humiliate, threaten, or manipulate the debtor. So, just like I said earlier, if they're getting that letter, if they're sending that letter, they can put a lot of stuff on there to make you open it. They can put on there, hey, priority or uh, do not throw away. It could be something like that, or important. I don't know if they could put do not throw away. That might be a little bit great, but they could say words like that to get the person's attention, but they cannot. And this is in the Fair Debt Collection Practices Act, is that they cannot put any markings that would signal that it is a debt collection letter or tend to humiliate, threaten, or manipulate the debtor. So that's a key word, manipulate. So if you feel, and I've talked about this in some past videos about uh, communications from a debt collector, from letters, and how you could feel that you were manipulated into either talking to them, and you were not ready to talk to them, or the way that the letter was sent to you, you felt that it was something that uh, manipulation for you to open it. And so e- even putting the word priority letter, even though the court said that it is not, uh, it could potentially be have an individual have a feeling of being manipulated to open the envelope, and that's kind of stuff is being argued in the courts with regular business, not just with debt collectors, on the wording that is being used, where they'll send a check in the mail and you'd be like, this is a check, and then it's a offer for credit, and people are like, when? And they feel that they were manipulated, number one, by it being a check, and then if it's a check and then it's not really authorizing credit, like you still got to go through a credit check process. Some people feel that that's a manipulation with the way that they sent that advertisement. Another one here is there is you they can't use wording. Here's a good one with Johnson versus NBC Collection Services. So no, they said here no violation to use terms in quotes, revenue department, personal and confidential on the envelope. Nothing in the inconspicuous design of revenue department distinguishes the letter from the permissible forms of correspondence, such as direct billing from creditors for debts not yet past due. The mere use of the department designation, revenue department, in return address of the collection notice is simply not the type of collection practice, abusive collection practice that the FDCPA was intended to reach. So, what they're stating on this one is that uh, this individual sued NBC Collections, NCB Collection Services, and they stated that they had put the wording revenue department, and the court in this case here said that even though they put revenue department, that can kind of infer debt collection or infer a collection of a debt, if it could be from the original creditor or debt collector. So in this case, they stated that that was not a violation. Now in this one here, Lindbergh versus Transworld Systems, the envelope with a system blue stripe and the word transmittal did not violate 1692 F8 because the symbol did not pertain to debt collection in any way, and the mechanical interpretation of section 1692 FA would not comport with the structure of purpose of the FDCPA. So again, in this one here, they had a blue strip over the top of the envelope, and they had the word transmittal. And so these are just ways to get people to open up the envelope. Just ways to get people to open up the envelope, because if they can't get people to open up the envelope, they disregard them. They're, you know, that's the first step of them making that communication, and they want to try to, increase their odds of people opening up the envelope when it's from a debt collector. This one here was Masudo versus Thomas Richards and Company. This is a debt collection company, and it says that an envelope containing a notice theft of mail or obstruction of delivery is a federal crime, as well as the words personal and confidential, and forwarding and addressing correct requested did not violate 1692 F8. Congress interest in protecting consumers, however, would not promote by prescribing benign language. So I guess in this one here, what they're stating is that um, with the personal and confidential, by them putting that personal and confidential, that it would, that would increase the attention of an individual who saw that letter, that would increase it. But they are stating that having that wording on there does not reach the level of a violation. This one here, Douglas versus Convergent Outsourcing, and we've all heard of convergent outsourcing. Court held that the collector violated Section 1692F because the debtor's account number was visible through the window of the envelope. Through the window of the envelope. You hear that? Account. Let's see here. This one here, this is one that was using here. Account number. If it's from the, that's crazy that they had the account number, but the account number could be, what they're stating is that the account number was the account number of the debt collection company. So with Douglas versus Convergent Outsourcing, court held that collector violated 1692 F8 because the debtor's account number was visible through the window of the envelope. So even with the wording of the name of the debt collector, Convergent Outsourcing, which would be in the return section, they had the debtor's name and that account number. Now, from experience, what I believe is that it was also done by a third party agency, because what they did is they printed out those letters in batch, and they were putting them together, and they had that number on there. So when they close them all up, and they want to prove to the collection agency that they sent out all of the letters, because they're going to get paid. And even if they don't send out one letter to them, could be thousands of dollars. So the debt collector is going to want to make sure that all of them were sent out. So they're going to want proof that the postage was paid for each of those, and that they were turned in. They want a receipt from the post office. They're going to want to know that all of that was done. And one way that the mail-in service would do that is by having that code on the front. So if they're either using a machine, it's going to say, okay, this one was done, this was done, this was done. And that the way that it'll read it is by having it with the name of the individual that they're sending a letter to. And it probably was not even the account number, but by simply having that number on there, it was a violation. So now the court declined to adopt the benign language exception, which, so it said that it did not violate that, but it did violate it with the having the account number. Nothing that the language of the section of 1692F was unequivocal, even if a benign language exception existed. However, the court held disclosure of the account number was not benign because it implicates a core concern, uh, core concern of the FDCPA, the invasion of privacy. I always talk about the invasion of privacy. I always talk about invasion. Really, if you think about it, one of the things that you could do, you receive a letter from a debt collection company, is that you could sit there, go to one of my videos or go back to this video, and you just listen to it and you look and you stare at that letter. And we're talking about the outside of the letter. We haven't even gotten to the inside of the letter. And we want to look at every piece of the outside of that envelope, front and back, front and back. As a matter of fact, on this one here that I'm looking at, it has a code right here at the bottom, on the bottom of the envelope. I won't show the person's name, but you can see, I don't know if you can see it right there, little code at the bottom of the envelope, and that could be brought up. See, and now you might be thinking, well, do I have to sue to get the job done on this? No, you don't have to sue to get the job done on this. What you can do is you can send a demand letter, and you can, take photocopies and draw lines to all of the violations, and then give them the option to cancel uh, the debt, to cease collection activities and to not come after you for that specific debt. That would be the way that you could do it. You don't have to end up going to court. So with our examples, you can see that the one, if they have final notice on there, that an original creditor can send a letter with the wording final notice on it. But when we're dealing with debt collectors, they cannot use the words collection notice. Uh, they cannot, as we just saw in this case, they cannot put the account number on there. And one way that you can double check that is when you open up the collection letter and you look at the file number, because they'll always have their own file number. And if that file number is anywhere in the window of your collection letter that you received, you already saw right there that is a violation, and you can quote that court case just in case you wanted to have some ammunition. It was Douglas versus, and that's Douglas with two S's, versus Convergent Outsourcing. It was a 2014 case, and nothing has changed with that. As a matter of fact, debt collectors have been making sure, well, most of them, I won't say all, because we still see a lot of them the wrong way, is that they're still, they've kind of cleaned up that, and they're not violating that. But what, just like um, what something that just came to my mind, something that came to my mind about people getting in trouble with debt is that everybody was. If you think about it, the reason why people don't know is because people were not always in trouble with debt. People that are, have went through it, had some debt collections, had some financial issues, went back and forth with debt collectors, paid some debt, saw how it hurt them with their credit. Like, they know about this, but there's people every day. Like, I had a call from a young lady, referral from one of my business clients, and she's a, a high income, high income. We're talking about probably about $400,000 a year income level. Ran into an issue because of a divorce, and was seeking advice on how she could handle this because she had actual collection notices from the attorney, and she was like, she had to go into debt to pay the attorneys. It was something over one of her child with her ex, and I was like, so the way that the attorney, she felt that the way that the attorney was dealing with her was unreasonable. And I was like, well, let's just kind of walk through what you went through, and because even though that it's from an attorney and the attorney did the work, so it's not like a third party, there's still some rules that must be followed, uh, when dealing with an individual and putting pressure, manipulating them, that type of stuff. They even original creditors have to be careful not to, to do that to people. We do all still have consumer rights also. We do have rights, but there's people every day that are like getting into this situation to where, hey, they never had been behind on nothing, and now they can't pay their debts, and now debt collectors are coming after them, and they're focused solely on the amount and what the debt collector is doing and saying, and they don't even know that they have rights, even with the way that the letter was sent to them from a third party debt collector. Like they don't even know that that is something that is a right to them. So that it's very important to always know your rights and to know. Also, it's not just about knowing your rights; it's about how to execute the information once you know your rights. Because you could know your rights and then you could, submit information to the debt collector, and it's like out of order, and the debt collector will just seem like they're not even paying attention to what you're doing. And it's not because what you're doing is not something that was a violation. It's that you're actually approaching them at the wrong time to where they don't have to worry about it, because there's certain periods of time that they're gonna have to worry about uh, debt validation. There's certain periods of time that you're going to have to worry about the way that they approached you with that letter. There's going to be certain times that they're going to have to prove the entire amount. Like there's certain times in the process, in the whole process of them collecting the debt, where they can disregard certain things that you send because it's not really technically it's not even time for that yet. Now you should do it and gather information, gather data, just in case they try to sue you, where you can show and have evidence that they didn't want to respond here. They had the opportunity to respond there. You reached out here. So the wording that they may use on there that they've attempted to do to communicate with you and you didn't communicate with them, and you got letters and uh, certified letters and statements showing what you asked them for and they never provided it for you, that might be where all of that gets used. But don't get frustrated because you're trying to do things in between and you don't get the result that you want, because sometimes they're not going to respond, because at that particular time for what you're asking them to do, they technically really don't have to respond to it. And that's the crazy thing about this, that they technically don't. Uh, Before I close it out, one good example of that is with the Supreme Court case that I had just made a video on this recent I think it was about a week ago, is that if a debt collector company buys your debt, they are considered the owner, and until they go into a debt collection uh, to start to collect the debt on you, they don't even have to respond to any debt validation, which is crazy. So, but that doesn't mean that you shouldn't do it. That means that you should go and do the things that you have control of. And then at some point, there's gonna come to a point where they're gonna send that letter to you, and you're gonna be more prepared. You're gonna have more information, or they might try to take you to court, and you're gonna be more prepared. So but they don't have to do a debt validation, and they are actually put into the position of the original creditor, which is crazy. This is just it is crazy when they're going after a debt that they own, and there's certain things when a debt collector who goes after a debt that they own does not have to strictly follow the Fair Debt Collection Practices Act, because this is a debt that they own. This is the wording that the Supreme Court has put into place, and I'm starting to see the debt collection companies really starting to test it. Now, this was something that was put into place in 2017, but just because something is put into place, sometimes it takes a little bit it's like they're going to test the water and be like, oh, that we don't have to do that. They test it again. Oh, we don't have to test it again. And then they're like, we don't have to do that. The courts are going to hold up what the Supreme Court said. So now let's just go crazy. Let's just go buck wow. And that's what they're doing now. They're sending out stuff and people are requesting a debt validation. They're not even validating the debt because they have no legal requirement to do anything under the Fair Debt Collection Practices Act if they own the debt. If they own the debt, so they can buy the debt, become the owner of the debt. Let me be clear, and you can look this up for yourself. Henson versus Santander Consumer USA. This is a Supreme Court decision, 2017. When they buy the debt, they become the owner, so they do not have to abide by the Fair Debt Collection Practices Act because they are the owner. So that means that they can go after you in a way that is not that does not make them have to follow the Fair Debt Collection Practices Act. And it has been tested, and now they're starting to really ramp it up. So, but I'm giving you information on how you can or what you can do. If a debt collector is collecting for the original creditor, they have to abide by the Fair Debt Collection Practices Act. If a debt collector buys a debt and they're uh, coming after you for a debt collection, even though they may have these be looked at differently under the Fair Debt Collection Practices Act because of the Supreme Court decision, I still say go at them with the information that is your rights under the Fair Debt Collection Practices Act. They may disregard some, they may pay attention to other, or they may say, even though they had this decision in their favor with the Supreme Court, they don't want to, be one of the companies that end up going into court over this when they could just forgive your debt. They bought it for pennies on the dollar and just say, just be done with it. Let's go after the thousands of people who didn't watch Steve's video with the credit repair shop. Let's just go after them and not go after this individual. Save us time, save us money, and we can just be done with it. All right. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, what makes us different, so you can see my 8-point validation process, my two-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grade your TransUnion, Equifax, Experian credit reports, and all 3 scores. If you have debt collectors coming after you early, grab my 3-pack of letters. Statute of limitation letter for debt that is past the legal statute of limitations to collect. My cease and desist collection activities letter that makes debt collectors think twice about coming after you, and my debt validation letter for the back and forth that might happen with debt collectors. Thank you for your time. Post your questions and comments. This is Stephen A. Williams, President and founder of thecreditrepairshop.com.